Good morning. So we'll go ahead and get started with our next panel. And I'd like to say that I too have been influenced and blessed by Jerry's work, and particularly his infectious enthusiasm for the issues that he explores, most recently in relation to digital sequence information and traditional knowledge. And I want to say that I appreciate his encouragement and support of my work and have valued the opportunity to work with Jerry in various fora. As we all know, database protection and digital sequence information are two of the myriad topics in Jerry's body of work, and we have a wonderful group of speakers to discuss these issues. We will hear in order from George Contreras, Jeremy de Beer, Jacques de Werra, then Toby Moody, and finally Paul Uhlir. They each will have 12 minutes to speak, and then we will open up for Q&A. George?
Great. Well, thank you. Yeah, I got it. Thank you very much, Margo, and thank you to the organizers for inviting me. So in my 12 minutes, I wanted to talk about a project that Jerry and I worked on a few years ago that highlights not his thinking as a legal realist, which Terry and others have mentioned, but as a pragmatist in the pragmatist school, which is, I think, a more proactive role than sort of the analytical realism that we often associate with these writings. And so there are three themes or trends that related to this project we worked on. One was the idea of the commons, and Jerry has worked on issues relating to commons of knowledge for some time, going back to before his sort of landmark 2003 paper with Paul, where he talks about the contractually constructed commons. The second theme and trend in this area was the sharing of scientific data, another topic near and dear to Jerry's heart. And then finally, how this all works in a trans-border way, how we do this across borders. And so a number of years ago, Jerry and I were invited by the National Science Foundation to participate as 2 of 10 US representatives in an international project called the Belmont Forum, which was conceived as a data sharing platform and project. And Jerry, you don't have to take notes on this, you were there. Anyway, just to refresh recollection, we went to Paris and Phoenix and lots of other places to talk about the creation of this open Earth data set and project with people from 14 other countries. And it was a worthwhile project and came up with this set of open data principles after a couple of years of effort, which shouldn't be particularly these should be very familiar to anybody who works in this area. Data should be discoverable, accessible, understandable, manageable, and these are quite aspirational goals. And I and Jerry asked, I think we were the only 2 lawyers from at least from the NSF delegation, what do these policies actually mean? They sound great and everybody is all for sharing and openness, but how will this actually work? Where is this data going to reside when the Russian Meteorological Society comes up with data? How is it practically going to be shared with the US Geological Survey and people in all of these other countries? Where is it going to reside? What are the actual rules in force going to be, to borrow from Elinor Ostrom's analytical framework for these sorts of things? Who's paying for it? Who's managing it? And so forth. And what we came to realize was that nobody really knew. That the end point of this and many international data sharing initiatives that we studied in the process was a set of aspirational goals and principles without a real on-the-ground practical implementation plan for these things. And so we set out to think about that a bit more. And in doing so, we looked at structures for data commons, as it were, and created a quite rudimentary taxonomy of them. which I'll talk about in just a minute. And so we start out thinking, okay, well, what is not a data commons? Not a data commons is one of these structures where you have different data sets out there in the world, different people contribute to them, and then the user accesses them separately. And that's not ideal. That is the reality for most data today. A commons, on the other hand, is often viewed and conceptualized as this fully centralized structure in which there are multiple inputs to a single repository, a single access point for users with some sort of centralized curation and administration, the sort of thing that exists in the human genomic space, GenBank, dbGaP, things like this managed by the National Library of Medicine are quite centralized and expensive. The NIH spends millions of dollars maintaining these databases, and for that reason, some of them, continue to drop offline as they are not used and as budgetary pressures dictate. And so there were pressures, we see, toward decentralized models for these types of common pool resources, moving away from an NIH, National Library, centralized structure toward more federated or decentralized models where you have multiple inputs, but where there are multiple repositories as opposed to one. And then as those pressures move us toward a more decentralized set of structures, there are particular issues that arise. And so one of these structures that we have observed is what we call an intermediate distributed structure, where you do have multiple repositories like this. You have multiple inputs to it, but the user, this person here on the right, still accesses them all through one single portal. The repositories are to some degree indexed together. They're searchable in some consolidated fashion, and there is some kind of administrator or central authority of some kind that can offer various value-added services to the group. And that's why you see the blue arrows in the middle here indicate that these separate repositories do communicate with each other in some way. And again, the person at the end, in viewing them all together, thinks of them as a single repository. And this is different than a fully distributed set of repositories. This is a structure in which you've got different repositories, and they are not technologically linked. You can't search them all together, but what links them is policy, right? And this is what we observed as what Belmont was moving toward, and what we have in many cases, but which is not really, or hadn't really been recognized as a type of commons structure. They are still separate, and the user has to access them and search them and attain data from them separately. Nevertheless, there are still some benefits to having a common policy structure surrounding all of these. And so part of this work was thinking about the costs and benefits of these different models, of which there are quite a few. I mean, some are quite intuitive. A centralized model, of course, requires staff. It requires IT resources. And it does offer a number of benefits for the user and benefits for the data contributors, whereas on the more distributed sides of things, they can be done more cheaply. But to differentiate one of these distributed commons structures from purely not a commons at all, you do need a common policy framework. And developing that policy framework isn't necessarily easy, and there really, as far as we were able to determine, there's not a good or a well-accepted methodology for doing that, right? For developing the technological linkages between separate data sets, federated data repositories, there is a well-established technological process for doing that, involving data exchange standards and their development. And many of these exist. On the policy side, not so much. And so what I've been working on lately, as an extension of this project, is thinking about a more methodologically sound way of exploring and implementing legal interoperability at a policy level between separate data repositories, primarily ones that are housed in different countries. And it raises three different types of obstacles, or three different areas in which interoperability needs to be considered. The international ones, treaty obligations, national legal rules, and then institutional rules. This has come up for me personally in the area of biobanking, in which you have quite robust rules at each of these levels, and creating an international biobanking resource or data sharing resource from biobanking requires the dealing with each of these different levels at which interoperability can be achieved. And of course, in some cases, it may not be achievable. And so there is a calculus of give and take in which there may be some jurisdictions that have particularly stringent rules in some areas. So take the GDPR, which is now implemented in Europe, quite stringent privacy protection. It's difficult to get around some of those protections. And so it may not be possible to have complete free data flow among countries. The alternatives when you are faced with that situation is either moving to the lowest common denominator approach so that everybody then complies with the most stringent regulations, or excluding the jurisdiction with the stringent regulation from the mix, in which case then you can have lower or higher, whichever you will, a threshold for exchange. Or the third option in this case is attempting to change the legal regime, either the institutional, the national, or the treaty regime, to adapt it. And that may be easier, of course, in the case of institutional rules than treaties, but in either case, that is sort of the third prong of an approach. And with those together, at least we have some sort of framework for approaching these questions. And so, in conclusion, I'll just say that the organizers of large-scale data sharing projects are often scientists who don't think that much or carefully about the legal issues involved. Other than that, there is something called the GDPR, and we all have to comply with it. There is a lot of additional work that can be done in trying to make these repositories communicate more and more interoperable from a legal standpoint, and that is work that I look forward to continuing doing. That's it. Thank you.
Thank you very much, Margo. Thank you very much, Irene and Justin and Ruth and your colleagues here at Harvard Law School for providing the space for us to celebrate Jerry's scholarship. We've been talking so far about Jerry's past scholarship. I'd like to talk for a few minutes about Jerry's future scholarship. There's a problem that Jerry hasn't solved yet, but can solve, and I believe soon will solve. So I'd like to imagine us 10 years in the future, looking back at the problem that Jerry's solved. Jerry has managed to rationalize the global governance of digital sequence information. So I'll talk about three ways in which Jerry's done that. First, I'll explain a little bit about what digital sequence information is. I'll describe, second, the evolution of the governance of digital sequence information. And third, I'll tell you what Jerry's done. So first, what is digital sequence information? Well, we have to understand this on both a factual and a legal dimension. So, in fact, digital sequence information is data about DNA, or genes, or gene sequences, or whole genomes. Digital sequence information, or DSI for short, can also be information related to genes and gene sequences and genomes. It can be information about the relationship between those things and phenotypes or taxonomies, or it can be knowledge about the way in which that data and information is used or applied. So we have data and we have information and we have knowledge, and DSI encompasses all of those things. What is profoundly challenging about digital sequence information is the decoupling of that data and information and knowledge from any material resources. It's the datatization of genetic resources. And that is a profoundly difficult problem. So in 2029, access to genetic resources no longer depends upon material transfer agreements or material at all. In fact, it only depends on access to the data and the information and the knowledge. So what is DSI from a legal point of view? Well, from a legal point of view, is DSI a genetic resource as defined by the Nagoya Protocol to the Convention on Biological Diversity? Is DSI a utilization of a genetic resource under the CBD? Is DSI data or a database? Could DSI be software or code? Could DSI be a literary work? Is DSI information? And if so, is it confidential information within the ambit of the TRIPS agreement? Or secret, trade secrets, in the context of our plurilateral trade agreements that are developing, or preferential trade agreements? Is it knowledge? Is it traditional knowledge? And so the real challenge here, and what creates the governance problem, is that what if it's all of those things at once? How do we solve that problem? So where has the governance of DSI been happening? First and foremost, it's at the CBD. You know that, Margo. And the CBD has, I think, taken the most proactive measures in response to the challenges of DSI through an ad hoc technical expert group considering these issues. But it's not the only organization dealing with this. The Food and Agricultural Organization of the UN is also addressing DSI in the context of the International Treaty on Plant Genetic Resources for Food and Agriculture, the Plant Treaty. The WHO is dealing with this issue in the context of pandemic influenza preparedness. WIPO is dealing with this issue peripherally through the Intergovernmental Committee on TK and associated genetic resources and cultural expressions. But it's not just the CBD or agencies of the UN. We've got private sector bodies or public-private partnerships where DSI is being tackled. The International Union on the Conservation of Nature, the WFCC, for those of you who don't know about that because you haven't read some of Jerry's work, it's the Federation for Culture Collections, the World Federation for Culture Collections, and the Associated Data Center for Microorganisms. We've got private sector organizations like George just talked about, and others like the Structural Genomics Consortium, another public-private partnership between pharmaceutical companies and universities. So the CBD seems to be leading in this area, but P3s are putting interim solutions into practice until we have clear rules for the governance of DSI. And in my view, the biggest threat, though, the biggest legal threat is the emergence of trade secrecy as the predominant issue for the expansion of global intellectual property rights through PTAs. And I think we have to seriously ask ourselves what the expansion of trade secrecy and trade secret protection means for the knowledge commons, the data commons, the microbial research commons, and so forth. Okay, so this problem was a hard problem to solve in 2019 when materials were at the heart of research, as with what Jerry's written about are known as digitally integrated genetic resources and data, literature. But once the data and the information, the knowledge becomes disembodied from the physical material, it becomes a whole nother ballgame. And that's when these institutional and organizational forces really collide to create the governance problem. So what has Jerry done in 2029 to have solved this problem? Jerry has rationalized the transnational governance of DSI. He is convinced the United States and Canada and other OECD countries that it is in their interest to solve this governance challenge, and reconciled the interests of developed and developing countries. He has inspired what in 2016 he called a grand bargain, built around a new intergovernmental framework and an organizational structure that puts science first and emphasizes flexibility and self-organization. The system, moreover, pays for itself by extracting benefits for all stakeholders, including scientific researchers, indigenous communities, and other stakeholders around this issue. So I'd like to end with a question. And it's a question that I think we've all asked Jerry, or all asked about Jerry's scholarship, and it's this. Jerry, how did you do that? Thank you.
Is the computer working?
Just hit escape.
Yeah. Is the password here? I don't know. Don't have the password. So,
Are we gonna need a
anyone?
password?
No password? Yeah. So maybe I can start without the slides, hoping that they will come soon. I first would like to thank Ruth, Irene, and Justin for inviting me and giving me the chance to be here and for putting together such a great conference. It's a privilege to be here, and basically, as you may have seen on the program, want to thank Justin particularly because he's helped me to come up with what I think and I hope is the longest title for a presentation in the program. And I was very happy to hear yesterday that, Jerry, you like long titles. So I hope you're happy with that title. But I'm actually going to change it as soon as the PowerPoint presentation works again. And I also would like, on a more serious note, like to thank you and pay tribute to your legacy, Jerry, in international and comparative IP law, which is, as we know, very vivid and lively everywhere, and specifically in Geneva, where I'm based. It's always great to see how much impact you've had and you still have and you will have, as we heard a minute ago, and it's great, and I hope we had a chance to welcome you back in June. I really hope to have you back very soon. So maybe it's gonna work at some point. So what I want to do basically is to come back to what Jorge Contreras alluded to, to talk not about international IP development, but to talk more from a GDPR perspective, to talk about personal data protection as a potential threat to data research commons, and to go back to the seminal paper that Jerry and Paul, and I'm very happy to be on the same panel as Paul, and to have the two co-authors of this paper dating back to 2003. And I guess I have to continue without the presentation, but that's fine with me. And to look at it from a data protection perspective. And one thing that I wanted to say is that under the GDPR, as you may know, it would have been easier with the slides, but anyway, I can just like make it in a nutshell here, is that under the GDPR, there are different grounds justifying the processing of personal data, one of which is consent. Consent of the data subject to process data. So there are other grounds which may apply and may be relevant also for research activities, including public interest or legitimate interest of the data processor. But if we stick on consent, and it's not clear, and I don't claim to be a GDPR expert, also because, as you know, I'm not based in the EU, but still, if you based your reasoning on consent, you realize that this may be risky for the reuse of personal data for research purposes. And the reason for that is that consent can justify the processes of data, but as you can read in the GDPR, this is Article 7, this consent can be withdrawn at any time and basically without any condition. So, which can be understood as a matter of principle, but which, as we can imagine, can be kind of risky if third parties somehow rely on the processes of this personal data to do research and conduct research activities. Now, what is also of relevance is to note that if we focus on consent as a justification for the processing of personal data, there is no privileged treatment for scientific research. So that means, as for the policymakers in the EU, and specifically for the so-called Article 29 Working Party, which used to be like a leading source of guidance for the application of personal data protection, now replaced by the European Data Protection Board. But for this body, they basically confirm in an official document that scientific research doesn't enjoy any specific and privileged treatment for the processing of personal data, which means, and they really mention that expressly, they indicate that as a matter of principle, if there is a withdrawal of the consent, then the processing of data must stop. So there is no way you can continue on that basis. So this is what we have under the GDPR. Now, what is new and why I think it's important to revisit somehow this topic is that we have another regulatory instrument at the EU level, which is a new directive which was adopted back in May, the so-called Digital Contents Directive, which sheds a new light on that topic. And the reason why I think it's important for us to revisit this topic is that if you go through the directive, you will see in Article 3 that there is a provision, which hopefully I'll be in a position to show you in a few seconds or minutes, if I still have the time. I'm not sure I can benefit from a time extension, but anyway. This provision is interesting because it indicates, wonderful, so thank you so much. I'm gonna go fast. So this is the paper that I wanted to refer to, sort of quick. This is what I wanted to focus on, and Jerry, you will see the title is as long as it was, so I hope you will be happy with that. And this is basically the focus. I can go fast because you know quite well the GDPR and its exact reference. This is what I was saying. Sorry to go fast, but I guess this is under control. Consent as a key justification for processing personal data. Withdrawal, which is something which can come. You have this different justification. One point that I wanted to add, this is in the middle where I indicated rigidity. What is very important to realize that under this GDPR system, for justifying the processing of data, if you choose consent, you cannot switch to another justification. I mean, you're stuck with consent, which means that if the consent is withdrawn, you're basically blocked in the future processing of personal data. Specific rules apply to like highly sensitive data with the same principle which can also govern here, which is the relevance of consent. consent which can be withdrawn, as I was saying. So this is also from a legal perspective important to realize that this is something which is a unilateral declaration. So you give consent, you withdraw consent, and as a result you can do it anytime. There are no limitations, no strings attached. As I was saying, this is what I was reflecting a few minutes ago about this document, which basically confirms that there is some kind of dependency of research activities if the processing of data is based on consent, and if that consent is withdrawn, there is no special privilege status. And this is where I had just stopped before computer was working. This is the directive I was referring to, which is important because, as you can read at the bottom of the screen, it, for the first time, at least to my knowledge, at the E level, indicates that you can somehow contract around personal data. You can contractualize personal data, which is an important question because it may mean, if we just look at it from a contractual perspective, that the fact of providing personal data to the other contracting party is a contractual obligation. With, of course, the question is, what if you don't do that? Does that constitute a contractual breach? With the question that you have at the bottom of the screen, is there a conflict that we may need to solve between what we've just seen about the GDPR, like unilateral declaration and the right to withdraw, and this contractual obligation to provide personal data in the context of a contract? And on that basis, you can see that this can be considered as some kind of a consideration. And this is the title of a paper which was published a few years ago, which invites us somehow to think again about this issue and to see whether there are risks and the threats which is posed for the digital research common, and how we can manage these two conflicting approaches, one which is like purely unilateral, like protecting very extensively the data subject, and on the other hand, of course, making sure that to some extent scientific activities can continue. And how can we, getting back to your paper dating back from 2003, we could potentially reconstruct research commons for scientific data. How can we look at it? And here again, taking maybe a more IP and IP licensing perspective. I think we should look at it in considering that when you grant to a third party the right to use your personal data, you're basically licensing to some extent personal data, as you would do for another IP asset. Now, if we continue, at least from a European perspective, and potentially a German and Swiss perspective, approach relating to a licensing agreement, you could consider and conceive that this licensing agreement cannot be terminated at will. There must be a just cause. There must be a compelling reason, if I use the terminology which was discussed in the course of the UNIDROIT principle of international commercial contracts, being noted, and this is important, the proposal for inserting this termination of a contract for compelling reasons has not been implemented. It was a draft, but still you get the sense that if you want to protect the other party, the users of the personal data, you may want to protect it in a way that the license cannot be terminated by the licensor without any single reason. So no more termination at will, which may conflict again, as we see, and as we've heard about the right of withdrawal at any time. Another thing about we may continue to think is to see to what extent we could somehow protect sublicensees. And there is an interesting line of cases in Germany, these two cases that you may have heard of, the copyright cases, in which somehow surprisingly, the German Supreme Court decided that in spite of the termination of the main license, the sub-license could continue. And you may think that if we were to apply this reasoning here, you may still have a protection of downstream users in spite of the termination, that means withdrawal of the consent of the data subject. So I mean, even if the main license would be terminated, the sub-license that you have at the bottom of the screen could potentially continue to be fully valid and enforceable. And one other thing I think we have to keep in mind, and this is a comment which applies, I guess, to all potential GDPR disputes, is to realize that there is somehow an indication in the GDPR that out-of-court settlement mechanism should and could be developed. And this is what you see reflected in Article 40 of the GDPR, which encourages the drafting of code of conduct, some kind of self-regulation. And I think that if we were to think about potential disputes arising with respect to the termination of these licenses, or withdrawal of the consent of data subject, we would need to search for solutions which would not be to proceed before courts, national courts, which would not be, I guess, to go before data protection authorities, because there will be too many of these issues, too many of these cases. So we have to think about what I've mentioned and indicators that like massive online micro-justice. I think we have to develop new tools to render justice for these personal data disputes. So I will stop here and thank Jerry very much for all you did for all of us and for me in particular. Thank you, Jerry.
All right, good morning, everyone, and thank you so much for the opportunity to be here. I want to thank Ruth and Irene and Justin. I really thank you for the invitation to be here and to speak with such a great panel. I do consider it not so much the testament of my work or who I am. I think it's more a testament of who Jerry is, that he's able to engage with scholars of every generation, I'll put it in that way. And I've been so honored to have had time to work with Jerry in, I think, up to in the past 2.5 years in the context of the work we do at the Center for International Governance Innovation. And Jerry has worked as a member of our traditional knowledge expert group, and he's been very active in providing suggestions and guidance, even in shaping up the work there. So, Jerry, I'm super grateful to you, and thank you for this opportunity. Today, I'm just going to reflect very briefly, and I think I just want to share two main ideas. The first, around traditional knowledge, defensive databases, and benefit sharing. The first main idea that I want to talk about is just the interplay of regimes and the importance of this interrelationship between the access and benefit sharing regime and the intellectual property regime in advancing solutions towards effective benefit sharing. And I know Jerry, in almost all our meetings, is always asking the question, why is this thing going on at WIPO? Why do you need to put that over there? But I think it's something I'll bring into this discussion and probably just provoke him a little bit this morning. And then the other part of the discussion will be just a reflection on databases, defensive databases, the defensive use of databases to protect traditional knowledge. And I'll be reflecting on some of the work that Margo in particular has done, just talking about the fallacy of defensive protection of traditional knowledge. And so hopefully within the time allotted to me. Now, very quickly, just as a context, I'm not going to bore you with discussions around biopiracy and what biopiracy is or not, but I just wanted to say that two main things that strike us, or two key sore spots that normally jump out in discussions of biopiracy, really are, on the first hand, the inadequate sharing of benefits arising from third-party uses of traditional knowledge or genetic resources. And in this instance, we see a lot of examples where indigenous groups do not receive benefits or are not aware of commercialization of their resources, and this triggers a lot of discussion around biopiracy. The second part, I think, is usually around the private intellectual property rights that are signed over uses of traditional knowledge. And these two, though they often come in most cases, I think that they also highlight this idea of biopiracy as a trans-regime issue, not just as a trans-border issue, and trans-border in that it deals with movement of resources across different borders, whether in situ or ex situ, but the use across borders. But then we're also dealing with an issue that sits across multiple regimes. At least in this instance, we can see the intellectual property regime and the ABS regime being implicated. And this is not to say these are the only two regimes involved. The significance of this is that solutions towards addressing biopiracy necessarily need to incorporate more multi-regime approaches, if I'll put it that way, thinking around multi-regime complexes in advancing solutions. Now, in terms of the protocol, the protocol has established the international access and benefit sharing regime, and Jerry writes in his paper for CG, on the Nagoya Protocol and its importance to science and industry in the US and Canada, and he talks about the difficulty in implementing this bilateral approach as contained in the Nagoya Protocol. And he talks about the difficulties of provider laws and retroactivity concerns, I beg your pardon. Also the high transaction costs, they also all play a role in making it a difficult regime to work through. However, on a parallel side, you also have the WIPO committee that continues to advance negotiations around the protection of traditional knowledge. And most recently, they have again made a recommendation towards the renewal of this mandate for the next 2 years. And in this new renewal, there is specific language that talks about the aim towards finalizing an agreement, even though it does talk about, again, that there's still a primary focus on narrowing existing gaps and reaching a common understanding on core issues. So there's still a question as to if this biennium is going to be the big biennium, but again, that's something that WIPO is dealing with now. The significance of WIPO in this regard has often been questioned. What is WIPO doing in this space? Why should WIPO be involved in questions around benefit sharing, protecting of traditional knowledge? And the thing, while I may not have a firm answer to that, I do believe that because there are intellectual property issues involved in the question of biopiracy in itself, WIPO as an institution, the global institution that deals with intellectual property, necessarily has a role to play in advancing ideas and solutions, even if it's as a forum for member states to discuss. And one of the things we see is that there are a lot of positive and defensive approaches and options that are being considered, including a tiered approach to the TK analysis, what Professor Ogwanimanam has also written on very recently. I also wanted to say that in Jerry's work, he does reference Article 4 of the Nagoya Protocol as being a critical article in bringing in or legitimizing external access and benefit sharing systems. And so those systems that are not necessarily under the Nagoya Protocol. I also feel that the WIPO committee can also be hooked into the Nagoya Protocol's discussion through that same article. Not necessarily Article 4.4, but 4.3, where it talks about complementary and talks about mutually supportive agreements, implementing the Nagoya Protocol in a mutually supportive way with other international instruments. And I do believe that an outcome from the WIPO IGC would necessarily fit into that article, such that the reading of the Nagoya Protocol becomes complete when it's considered with the outcomes of the WIPO IGC. And I think that's why the work at IGC is very significant for many reasons, because, as has been said many times, the work in the Nagoya Protocol still leaves a lot of gaps unanswered, which member states, again, are trying to deal with and resolve at the IGC. Now, one of the key things that has been raised in the IGC as a solution to addressing biopiracy, or this textual development, is the use of databases. and the delegations of Canada, Japan, Korea, and the US did submit in 2012 a proposal to have a database, like a one-click massive database, which would basically support in place of a disclosure of origin requirement, but this would basically be helpful in supporting the protection of traditional knowledge. Now that proposal has been submitted consistently in the IGC since 2012 till date, and it continues to be a working document. More recently, I think first was an information document, but now it really is a working document that is constantly submitted. And we've also seen that that article has probably triggered an insertion into the TK text of a reference to databases, and it does talk now about member states should endeavor to facilitate and encourage the development of the following national traditional knowledge databases to which beneficiaries may voluntarily contribute their traditional knowledge. And so the question then has been, how viable could databases for documenting traditional knowledge, how helpful can they be in addressing the problem of protecting traditional knowledge? Now, it's often, in the IGC, often looked at many times as an option that can exist alongside a disclosure of origin requirement. And in some other instances, it's being pushed out as an option that should exist outside that kind of option. And to that second part, where you think about defensive uses of databases, this is where Margo's critique comes in very helpful. And she argues in her recent paper on the fallacy of defensive protection for traditional knowledge that, that while it is helpful to have defensive protection for traditional knowledge, there are huge concerns where there isn't a corresponding positive obligation. And so when you have defensive, when you have a defensive, when you use databases without positive protection, then you actually could result in even worse outcomes, because then what happens is that whether it's instances of failed application patents, these become part of the public domain. They are open for access. Even in some instances that she had raised one of the cases, the Avon case, there was an opportunity for an applicant to go back and amend its claims such that it could capture what should not ordinarily have been covered under the protected, I beg your pardon. And so I think that just her point at the end of her article is that database gives no protection that TK would not have outside the database. And I think that's a strong thing to think about, especially in advancing solutions within the IGC. Is it possible that while we're looking at database options, we're also looking at strengthening the right of positive protection alongside? Now, I'll just conclude with those 2 points that I've made, that positive and defensive protection approaches should be combined, I believe, for effective TK protection, and also that trans-regime solutions need to be pursued, incorporating synergies across IP and ABS regimes. Thank you very much.
So may you live in interesting times. I know that as IP professionals, you always do, but I also mean it as the apocryphal Chinese note of caution. I'm sure you know what I'm alluding to, so I won't belabor it. I was, however, somewhat surprised that no one commented overtly about the 3 main themes defining the symposium. Except arguably for the first one, it is orthogonal to our times, so kudos to whoever thought this up. Although I'm not an IP professor, I know many of you from previous interactions and meetings, so it is nice to see old friends again and make new ones. As you have seen, I distributed a bit of satire that I wrote about 2 decades ago. Amazingly, not with Jerry, which is appropriate for the theme of this panel. I only think Jerry and Rochelle saw it at that time. Although an internet tale is somewhat dated, having been written in light of the database IP events in Europe and the US in the late 1990s, many of the themes in that piece remain relevant today and echo a lot of the issues raised by Jacques and others yesterday. These include the strategic behavior and extraction of monopoly rents by the major economic players, their use and misuse of technology to maintain dominant positions, the revolving doors between the regulators and the regulated, and the cynical grandstanding on law and principle to justify their behavior. You can read it at your leisure. I'll divide my two remaining topics into a little reminiscing of my friendship with Jerry and in raising some highly disruptive issues about database law and technology that are on the horizon. I've known Jerry as a professional colleague, mentor, and friend since 1995 when we first met, thanks to Pam Samuelson, in the context of a study committee I was forming at the National Academy of Sciences. That report, Bits of Power, was written in the 1995-96 timeframe, which turned out to be most fortuitous. As most of you will recall, WIPO convened a diplomatic conference in December of 1996 that was supposed to enact 3 treaties, the third of which was on a novel sui generis legal right for the protection of databases. Earlier that year, the EU passed a new directive on the legal protection of databases, and although there was no experience with that legal regime in national law in Europe, much less anywhere else, contrary to past practices, WIPO was set to pass the treaty along those lines. Also that year, Jerry wrote a chapter in the Bits of Power report that showed the potential negative consequences of the overprotection of databases for research. So we drafted a letter that was sent by the presidents of the 3 national academies to Vice President Gore and CC'd everyone in Washington, extolling the substantive and procedural dangers of the proposed database protection law. That letter caused a major kerfuffle and was instrumental in changing the PTO's support of the Database Protection Treaty and ultimately to stopping the WIPO treaty at the end of the year that Jerry was lobbying on behalf of the academies. So we spent the next 5 years lobbying in the US Congress and on behalf of the academies in the database wars. We were part of a coalition of academics, librarians, internet service providers, and other ne'er-do-wells. And we worked a lot with Peter Yazzie, Justin Hughes, who was at the Commerce Department at the time, Jonathan Band, who's not here, and others. Needless to say, we became persona non grata with Elsevier and other big international publishers who were pushing the law in the US and internationally. In preparing for the symposium, I tallied up the pages of legal books, articles, and reports that I have co-authored and published in various IP and academy outlets with Jerry over the past quarter century. And it comes to over 900 pages in the independent press and about 700 pages in 4 National Academy of Sciences reports. And that doesn't include the work we did on drafting legislation, testimony, and other official memos. So we met in Durham, Washington, New York, and actually in all corners of the world, spending many, many days writing and arguing and consuming oodles of fine wine and food. It must have been fun, or I wouldn't have done it for 25 years. We are now finishing an article on the inclusion of genetic data in the CBD treaty regime that others have alluded to, and what to do about that. And afterwards, I'm sure there will be something else. So here's to Jerry. In light of the most recent article, I will spend a few minutes of the last part of my talk that is also its title. I begin by reiterating something I wrote 25 years ago, or 15 years ago. This audience knows well that factual data are fundamental to the progress of science and innovation. The rapid advances in digital technologies and networks have radically altered and improved the ways that data can be produced, disseminated, managed, and used, both in science and all other spheres of human endeavor. This has created unprecedented opportunities for accelerating research and creating wealth based on the exploitation of data as such. Every aspect of the natural world, from the subatomic to the cosmic, all human activities, and indeed every life form, can now be observed and stored in electronic databases. There are whole areas of science, such as bioinformatics and molecular biology, and observational environmental sciences, that are now primarily data-driven. So although this was certainly the case already some 15 years ago, it is even more so today. Since that time, there have been many rapid scientific and technical advances, some of which are game changers. There also have been continuing explosion of data and the technologies for mediating them, although we have not become commensurately wiser. The human systems always lag the technological ones. In 2011, Craig Venter and his group filed the first patent for creating a microbe from a digital sequence, a blueprint for manufacturing life. Other patents of this nature have since been filed, auguring the dawn of synthetic biology and the emerging equivalence of materials in the life sciences and their digital manifestations. Moreover, additive manufacturing, known colloquially as 3D printing, can take a database describing any physical object and recreate it by printing it out. So we now have begun printing guns and butter. Hence my premise that everything's a database. From the perspective of the life sciences community, the expansion of the definition of genetic resources to include digital genetic data in the Convention on Biological Diversity, or CBD, as others have already talked about, that legal regime must not create new barriers to expand old ones to access and use of data or expand the old ones. Both the profit and not-for-profit researchers have an interest in open science and open data flows to support their research. In the case of researchers in commercial endeavors, open data can lead to greater innovation and resulting profits, whereas academic researchers want to minimize costs and use the data for new research. The questions for both kinds of researchers is to accomplish these goals to preserve the open flow of genomic data in the CBD context, and whether to block the inclusion of that in the scope of the CBD or to carve out a space contractually using appropriately structured MTAs. The duality of reality that is increasingly manifesting the equivalence of the in vitro material and in silico databases that contains the blueprint for all physical material has profound implications from a variety of perspectives. I will only briefly examine the emerging legal implications of the CBD context. But as you've already heard, Jeremy DeBeer raised most of these already, so I will be brief. In the digital and material worlds, if the digital and material worlds are becoming equivalent, what does that mean for the copyright and patent regimes? Different legal systems and jurisdictions have different answers to these questions, and the law is far from settled. If genetic sequences are not copyrightable subject matter due to under IP law, there are And a lot of the sequences, yeah, okay. And the sequences are in the public domain. And life forms are not patentable in some national jurisdictions. Will other legal approaches become more important? Will contracts become, will contracts among parties supplant them and reign supreme? Contracts and licenses, and the power of the two-party deal, as Jerry calls it, are now broadly used for transferring all kinds of digital objects, both in commerce and in the nonprofit arena. Will trade secrets, which increasingly are displacing patenting in areas such as microbiology, make digital life science data more closed and generally unavailable? Will sovereign rights of states, a kind of public corollary to private trade secret law, be used by states to control and hide both genetic materials and their associated data to the detriment of open science? The same can be said of traditional knowledge and indigenous sovereign rights, as we've just heard. And moreover, who will call the shots? If the physical-digital duality can be overcome by the highly contentious parties to the CBD regime, and that's a big if, a major technical aspect with fundamental legal implications is one of infallible tracking. That is, can ownership of any given object be established with certainty, and can the chain of custody then be determined? This is a pressing question of establishing trust, which is very much lacking. So as you know, the tracking of material genetic resources is difficult and can be expensive. And ascertaining the provenance of digital data after many transfers and permutations can be impossible. It may be irrelevant as well. So in conclusion, I would say that the cat's out of the bag. That is, no amount of protestations by the naysayers of the duality of the physical and digital in the context of the CBD can make it so. The duality exists, it is growing, and it cannot be ignored. It therefore could be a lose-lose situation in the context of that treaty. How can we break out of such an impasse and arrive at a win-win outcome? Jerry and I and our co-authors in Amsterdam envision a scenario that would arrive at a multilateral accommodation without a new treaty. But in the exploration of the many issues underlying the inevitable notion that everything's a database, I sense a new article. Jerry?
Great, well, those were all wonderful presentations. And to begin the Q&A, I'm going to give Jerry the option to ask the first question or answer a question that's already been asked by Jeremy. How did you do it? We need to know.
Well, thank you for the wonderful talks, and I can't wait to get your paper. I would make three small comments. I just would make three small comments. You have no idea how close we came to having a database protection law in the United States. You have no idea. And all I can say, you do. All I can say is that the work of the national academies on that regard in fighting that off was just indispensable. And Paul was as head of the data board of the national academies, was behind that. And I would add that you have no idea how close we came to having obstacles to fair use inserted in the WIPO copyright treaty that was being negotiated. And again, thanks to the National Academy and to Paul, we were able to, on the contrary, we have clauses in the WIPO copyright treaty that, when you know how to read them and you know the background, actually directly, expressly protect fair use. It can't be outlawed as a result of that. One thing I want to leave you with, because my time is limited and I will not have time to write another article on it, but there's an idea that I've been putting around that I would like to share with this larger body. Okay, we have the traditional knowledge, and it's going to be protected in one way or another. And what are we going to do about the fact that everybody is using it or has been made using it and will be using it, etc.? I think we should consider something that we used to have in copyright law. We don't have it anymore, although the Italians had it until very late. And it's something we can learn something about from the past. This is the paying public domain, domaine public payant, so that if we get this protection of traditional knowledge, and if we end up clashing with some uses that come along after that protection, we may be able to just solve the problem by imposing the payment of a tithe for continued use of this that does not have the possibility of an exclusive property right, can't be removed, can't be sued out. But you may impose a duty to pay. Italy actually had this paying public domain in copyright law until the 1970s. And it was quite interesting because you could not drive the alleged infringer out of the market. All you could do in the worst possible case was force a payment of a reasonable tithe for continued use. And I really want to leave this idea with you, because it's not something that hasn't been done before. It's something that has been done before, became obsolete in copyright law, but it could become really a strong instrumental solution for this, all the ambiguities we have with traditional knowledge. So if it became a worst case that you had to pay a tithe, that might not be the worst possible case in the world, and it might close a lot of other options, more drastic options, off the table and let us move on. I leave that there. Thank you.
Thank you. So I'd like to gather a couple of questions.
Thanks. I got a question for Jacques. So I was intrigued by your term massive online micro-justice. So I understand that to refer to the level at which justice is administered rather the amount of justice the users receive. And in that context, I'm somewhat worried, like how in an ADR, ODR context without proper oversight by courts can one guarantee due process and fairness? So what your thoughts on this are? Thanks.
Shall we collect questions or shall we?
Yes, let's collect a couple more questions.
Thank you. My question goes to Toby. I was wondering whether you have explored the avenue of referring to unfair competition rules in addressing TK issues. I just mention it because it's in Article 12 bis of the Paris Convention, and it's part of the TRIPS agreement, and it's enforceable law. And we have seen now a case where for the first time in plain packaging, the concept has been expounded by a panel here. And I think if you take a classical case of buyer prospecting or company using traditional knowledge, making a benefit, I think that could be dealt with on a case-by-case basis to protect these communities and to achieve a greater amount of distributive justice in the field. You didn't mention it, so I wonder whether this is something you deliberately leave aside or whether this is an avenue which could be added to your multidisciplinary approach.
One more question. Okay, well, we'll go with those that we have right now. So,
Shall I
Jacques?
go first? Thank you for your question. What I was alluding to is basically a development which goes way beyond the topic that I presented this morning, which can be illustrated by the so-called right to be forgotten. I'm sure all of you are familiar with that, resulting from that court decision of the Court of Justice of the EU from 2014, which, as you may not necessarily know, led to, I think, as of today, approximately 800,000 requests to Google, which basically had and still has to make decisions on that without, if you look at the statistics, like being really submitted to very intensive guidance or supervision. And the point that I want to make and the connection to this discussion here is that only a very, very limited fraction of the people and the claimants, if Google decides negatively, go to court. Why is that? Because it's too long, too expensive, they're not going to do it. So we need to think like innovatively about new dispute resolution mechanisms, which may, and that goes back to the topic of today, which may apply also with respect to dispute about the withdrawal of the consent. I don't expect people to go to courts if for some reason their personal data continues to be used even after they withdrawn the consent. So I don't think courts proceedings will be the solution. I don't think that administrative proceeding in front of data protection authorities will be the solution. So we have to think creatively, potentially online. And coming to last point, I terminate here. I think we can have confidence in developing fair, reasonable, and equitable ADR, ODR system, which can treat, respect due process. And I think we also have experience for that on the basis of standards mechanisms such as mediation, arbitration, for which I think we can really have hope and confidence that they can be helpful in that context.
Thank you, Professor Cotier. And that's a great question, and thanks for that. I didn't include it. I didn't mention it because I hadn't considered it as part of the discussion, and I think it raises a very good point. One of the concerns I think that could come out with that use is that not all instances of TKUs are necessarily commercial, and so there could be it will capture. I can envisage it capturing a major part of commercial uses of TK. But then for those aspects of indigenous knowledge that, for instance, are secret and that other aspects are infringed, that go deeper into the roots of who the community are. And I think that for that, there might still be some need for other rules. And so it's an area that I would love to include in the paper, just for what it can add, because I do believe it does contribute something. But in terms of the broader discussion of protecting traditional knowledge, I think indigenous peoples are still pushing for something more than a pure, competition approach to protecting traditional knowledge. Thank you.
All right. Thank you. Please join me in thanking the panel.